What are the duties of an executor after a death in Arizona? Hi, I'm Attorney Paul Deloughery. And first, let me say that Arizona calls the person in charge of a deceased person's estate a personal representative and not an executor. But nevertheless, let me answer the question. So I'm going to be using as my cheat sheet what we use here in Arizona, which is the Order to Personal Representative. And you can just find this on Maricopa County Superior Court website. It's a form. If someone's already been appointed as personal representative, then there should have, well, no, there needed to already be this signed so you can get a copy just from the court file. In any event, I'm just going to be going point by point here, and if my memory is right, I think there's 17 of these. So here we go. Number 1, fiduciary role. As personal representative, you're a fiduciary. You need to act with fairness to beneficiaries and creditors. Never use the estate's assets for personal gain and avoid conflicts of interest. Number 2, mandatory notices. So within 30 days of being appointed, you need to notify the decedent's heirs and devisees, the people who are supposed to get the stuff, in other words, about your role and any relevant court orders. Inform them of the will being admitted to probate, if there was a will, and that they have 4 months to contest it. Number 3, document compliance. So within 45 days of appointment, you need to prove to the court that you've provided all notices to the people who are entitled to notices. Okay, and again, it's all spelled out here. If you have a question, give us a call, talk to your lawyer. Okay, number 4, notice to creditors. You need to publish a notice in the local newspaper for 3 consecutive weeks and directly inform known creditors that they have 4 months to present claims. So known creditors, unknown creditors have 4 months from basically being notified that they can present a claim, and if they don't do it within that time period, then they're out of luck. Okay? Number 5. Manage estate assets. You need to identify, secure, and manage assets, obtain a tax ID number for the estate from the IRS, handle assets through a separate bank account for the estate, and avoid commingling with personal funds. So you can't just take the deceased person's money and put it in your personal bank account. Okay, can't do that. All right, moving on. Number 6, restricted assets. So comply with court orders on restricted assets, file necessary documents promptly. Inventory. Create an inventory of the deceased person's assets within 90 days and share it by either filing it with the court or mailing it to the heirs or devisees. Number 8. Determine statutory allowances. So determine if anyone qualifies for certain allowances that are set out in the statute, and yeah, they're actually listed here. I won't read them, but so basically there's something called a homestead allowance, there's exempt property, and a family allowance. So if you have a question about that, give us a call. 9. Keep detailed records. You need to keep detailed records of all transactions, including receipts for expenses. 10. Taxes. File necessary tax returns for the deceased person and the estate, and pay any taxes that are owed. 11. Address claims. You need to identify valid claims and expenses of the estate and pay them. Handle any denied claims promptly. Okay, and then asset distribution. Distribute assets according to the deceased person's will, or if there wasn't a will, then according to Arizona's intestacy statutes. 13. Update contact information. If your contact details change, notify the court promptly. Almost there. Compensation. So, if eligible, you can receive compensation for your services. So keep time records detailing your work. 15. Court involvement. Typically, estates operate with minimal court involvement unless an interested party, requests that the court get involved. And then 16, close the estate. So after administering the estate, it needs to be closed, either formally with a hearing or informally by just filing a closing statement with the court. And the court expects that to happen within 2 years. And then finally, seek legal advice. Always obtain legal advice on your duties to avoid being personally responsible for mistakes. So let me repeat that. If you as personal representative or executor make a judgment call or guess about what you're supposed to do because it seems right, and you make a mistake that costs money, to cost the estate money, for example, you can be held personally liable. So, for example, I'm recording this in 2023. Here's a real, this is going to be a hot issue. Someone who gets appointed to administer the estate, gets appointed as personal rep, and decides to hold on to the real estate. And then the market keeps going down. And I'm not giving any advice here about investing in real estate or what's going to happen. But if the market goes down and you could have sold the home now and you chose to keep on to the home, to keep the home, I'm not sure why. And the market goes down, and as a result, for example, the estate loses 20% of the value that it should have had, you can be held personally responsible. So that was just a quick example. Anyway, remember, this carries significant responsibility, and it's essential to act in the best interest of the estate and in accordance with Arizona laws. So, thank you for watching. If this was helpful, please give us a thumbs up and subscribe so you don't miss future videos. And if you have a specific question or want any help, just give us a call at 602-443-4888.